Once again, we are going to start our presentation by Tahira Dean from Legal Aid of Marin with Natalie Lopez providing interpretation as needed.
Great, thank you. Hi, everyone. Thanks for coming out tonight or tuning in. My name is Tahira. I'm an attorney at Legal Aid of Marin. And here today to talk about tenants' rights with everyone. Happy to take some questions at the end. Just please hold your questions until the end. We have regularly done some programming with Marin County Libraries. Really fantastic to be working with them to provide more information to the community about what's going on with rental assistance, if there's a moratorium in place, how to get one security deposit back. The library has been really a great partner in just being able to share the information with the community. And if people need individual consultations, Legal Aid is able to assist in the future. After this presentation, I will be able to give you my information so you can contact me. So who is Legal Aid of Marin? We are an organization located in San Rafael. We offer free bilingual legal services for low-income Marin residents. Our practice areas are civil fines and fees, which is community court. So anyone that has a traffic ticket is not able to pay it, they can go through community court process to get use community service hours to work off the fines. We assist in some area variations of elder law. We do employment law. Anyone that needs assistance, with an issue with their employer, even if they're just a day laborer, we're able to assist in negotiating to get any unpaid time back. We also, our other big area is housing law, and that is my area that I'm working with my colleague Josh Sullivan. We are able to assist on a wide range of different areas, tenants' rights issues, but mainly, with these days we're dealing with eviction defense. So anyone that is being evicted needs to go through the court process. That's our biggest focus, to try to get people housed. Today's presentation is going to be focused on kind of preventative care and addressing things that are common issues that we see regarding habitability, a need for knowledge about rental assistance, and as well for security deposits. Those are really big issues that we're not always able to take on those cases because they're in such great need. So many people have mold issues. So many people are fighting with their landlords to get the security deposit back. But we're trying to arm the community with information like this, like these topics, so that people can be able to advocate for themselves and navigate the systems on their own. And I do just want to say, si necesitas interpretación en español, puedes, poner en el chat. Natalie Lopez está aquí para traducir. So just let us know for new people that come in if you need a Spanish interpretation. So the first question we're going to address is, do tenants have the right to demand a safe and habitable home? And the answer is a resounding yes. All tenants in California have the right to a safe and sanitary home, including repairs. A lot of landlords, let homes go into a state of neglect and disrepair, and tenants think that they have to just deal with it and not complain, and they don't want to make a fuss. They don't know how to get their landlord to make certain changes. Here is a list of examples of things that make a home not habitable, and that you can go to your landlord and try to get them to, demand that they make the corrections, make changes, and repairs, and you can take further action if they completely ignore your request. So if your home is damp, if there's leaks in the ceilings or walls, if there's plumbing issues, drainage problems, if there's holes in the walls, floor, carpet is really messed up, if there's visible mold, if there is inconsistent, consistent rats, roaches, insects, pests in general that are coming in, and you haven't caused them, you try to correct the issue and they're still coming. falling plaster or peeling paint, defective electrical wiring. For sure, if there's no hot water, no heat, if there's electrical outlets that are broken, those are big ones that landlord needs to provide you with. Also things like an inadequate trash collection, unsafe stairs or railing, inadequate security or locks. These are all bases for which, the landlord needs to make corrections. Now say, for example, one area that gets sticky, like for carpet that has been there a long time, that it just needs to be repaired, and replaced, but the landlord's not doing anything about it, that might get a little stickier. We had a case in which the carpet was so old that it was causing someone to have asthma, because it had been there for so many years and just had a lot of different allergen, different dust and old things that were stuck in the carpet. And our client was able to make a case that they needed that to be changed out for health reasons. So that's an example where the carpet can be seen as something that makes a home uninhabitable. But there are going to be some cases where it's just there's not that much you can do about it. So it is very specific to your circumstances, and how long the situation has been in a state of disrepair. But regardless, here's some steps in which you can take to address these issues, right? One is writing a letter to your landlord. If the case is really severe and it is a case in which all apartments are dealing with it, say there's a rat infestation in many units, that is a scenario in which we are able to write a letter on behalf of all of the tenants. And that's something that we've done before, and we're able to address that. When it comes to some individuals that it's just it's a case-by-case scenario, but in other circumstances we're able to give you a template letter, and you're able to to show you how to write that to your landlord on your own. A second way in which you can be able to get these issues addressed is through code enforcement. So through the county, you're able to, you can just Google them, Marin County Code Enforcement, and file a complaint online. If your landlord has ignored your request to, do repairs, code enforcement will come out and inspect the building, the unit themselves, and they'll see, if something is not up to code, they'll be able to contact the landlord directly and list the changes that need to be made. If the landlord refuses to make those changes, that they can be fined by the county for not making those changes. The last thing, if those two areas aren't working, they're not providing satisfactory results, you can go to small claims court. And any repairs that you had to make on your own, say you had to call and get the plumber to come, and your landlord's not paying you, not reimbursing you for the plumber coming out after you requested several times that there's a broken toilet, you can try to go to small claims court and file a complaint against your landlord, so that you can be able to get the money back for the repairs that were made. We have a case where a client was not able to get the landlord to pay for damages due to mold, and the issues that resulted from a big mold problem. And they had a long list of different areas in which the furniture was molded and they needed a replacement. They were able to take their demand letter that went unanswered, and go to small claims court, file a suit against the landlord, and claim that amount of money that they need back. That client can also argue that the time that was spent in the home with the mold is also time that they can try to get money back for rent paid, for which they were living in the home in such really bad circumstances. They have photos to show the proof. That's the kind of proof that they'll need to go to court. So that's another option. We do have a lot of clients that go to small claims court. It is a court in which there are no attorneys allowed. And it's a process that is there for individuals to go and be able to get some justice when they can't afford to pay for a lawyer. It's a simple enough process where the judge is able to talk directly to the individual and the tenant in this case, and be able to help them get money from their landlord, in which they were not able to before. Trying not to talk too slow so now I can translate properly. Not talk too fast so I can we can have effective translation. So yeah, so the next area we wanted to address is security deposits. We get a lot of complaints about landlords not giving security deposits back, either taking partial security deposits or the entire thing. We want to set people up with expectations about how to prevent issues with security deposits at the beginning. So when you're moving into a new place, you should always take photos. Take photos of the home as it is, as it was given to you. Take videos even, and so that and save that somewhere on your computer, so that when you eventually do move out, maybe a few months later or years later, you'll be able to reference the state of the place as you took it in the beginning. At that time, if you notice that something's broken or damaged and the landlord hasn't written it down when they're doing a walkthrough, make that known to the landlord at that time. You want to do a walkthrough at the beginning too, so you guys can both see the state of the situation and address issues at that time. And then throughout your tenancy, anytime there is a need for maintenance, you need to document that. Maybe there is an official system through your complex in which you're documenting that online. But if there is not, you want to have everything in writing. Even if you're just texting your landlord, you want to save those texts. Like, on February 2nd, I asked the landlord, I texted landlord that the toilet is broken, or, XYZ needs to be prepared. If you keep record of all those and the landlord hasn't never made those repairs, they can't ask you, they can't, take money from you for that thing being broken. If you made them aware it wasn't your fault, you didn't cause the broken door or whatever. As long as it's documented, you'll be able to go back to that at the time of move out. So upon move out, you should review the move out policy and your rental agreement. Make sure that you have given sufficient notice before moving, because a lot of people don't understand the period of notice that they need to give before moving out. So if they break the lease early, if they don't give sufficient notice, then the landlord can take from the security deposit. You want to always clean thoroughly when you're moving out. Some of our clients even hire cleaning services so that they can make sure that there is nothing at issue. Everything is completely clean, so that's not going to be an issue. Sometimes landlords have cleaning services go in there and they charge a lot of money to the tenant, and they take out a security deposit. So you want to prevent that. You also want to take photos and more videos when you're doing your walkout because you're not going to be able to go back there after the landlord, after you've given the keys. You can't go back and dispute anything with a walkthrough again. You'll have the video and the photo there to show, to dispute any charges at the time. And once again, you want to schedule that walkthrough with your landlord. I even had one time when I was renting in San Francisco, and the landlord was like, well, walkthroughs aren't part of our normal thing. We don't really do that. But for my own comfort, I wanted to walk through the apartment and show him, like, this is, this was broken here. This was, like this when I moved in, so that we both were on the same page and there was no misunderstandings. So, even if it's not something they are customarily do, if they're nice enough, they'll schedule the walkthrough with you and before you drop off the keys. Okay, so once you are ready, have already moved out, don't expect the security deposit back immediately. California code says that the landlord has 21 days to return your security deposit. So you have a little, be patient within the 21 days. If, they are trying to take money from your security deposit, they can wait till, the 20th day and then, or the 21st day even, and provide you a written list of what they're taking out for, an itemized list of the deductions. So, for example, if they need to, have a painter come in, and because the walls are really all black with different marks from a child writing on it, and they need a painter to come in and, completely paint everything out, and they'll have to send you an itemized list of the name of the painting company, how much they charge, and the date in which they came in. And, that's that list that they need to provide to you if they're going to take money out of your security deposit. So, and in the letter, they also need to just write and explain like why that's being withheld. And that's the starting point for you guys to go back and forth and discuss, the reason why they're taking it out. So when people come to us with security deposits issues, we're not always able to assist with those issues to address the landlord. But we do have template letters in which we're able to, guide people to writing this letter on their own to refute it. If there's language issue between the landlord and the client, those are the scenarios in which we're able to assist a little bit more and help the individual to get the security deposit back. If it's a really, really really big problem, something that's a very obvious issue. Like, for example, we were seeing at the beginning of COVID, COVID cleaning charges, that was the reason for a deduction in security deposit. That was a really obvious kind of abuse of power, because, COVID cleaning, like no one can help that we're all in COVID. The landlord needs to clean between each person. So when they're charging like $500 for a COVID cleaning, and when, there's COVID everywhere, and, that was a circumstance when we were able to write it on the landlord's behalf, on the tenant's behalf, and intervene. But yeah, if you come to us, we'll be able to guide you in writing that letter. And normally, when tenants stand up for themselves and address the issue with their landlord, they're able to come up with at least a middle ground. But maybe they won't give back the entire deposit, but they'll give back a portion. And one other area that I forgot to mention is that the standard is the landlord can't charge for normal wear and tear. So if a tenant has been someplace for 10 years and the carpet is just, it's worn out, it's not like it's not covered with, lots of damages, it's just worn out because it's been 10 years, the landlord can't charge to replace that. So that's a really important standard to remember. Right now, we are in a state within the land of renter protections, where there unfortunately are no renter protections for the moratorium that are existing. And so right now, as of today, and the law does change, every few months, but there are no protections if someone cannot pay their rent for the month of May, right, in June and going forward. However, if someone, is getting, still hasn't paid, like say March or February, and they did apply for rental assistance with the county, they are protected. So, if someone comes to us with an unlawful detainer eviction notice for, February, and they have proof that they applied through Marin County's rental assistance program for rental assistance, those folks are protected until the end of June of this year. But everyone else who needs rental assistance from this, from April going forward, they'll have to go through these organizations that may have as of right now, most of these organizations still have pools of separate money. They do all work with the county to be able to provide rental assistance, but they have their own separate funds, even before the pandemic, in which they're able to assist individuals on a case-by-case basis. So if, try going through, some of them might have long, queues and backlogs too, but try going through these different organizations and seeing if you're eligible to receive 1 month's rent, assistance in the form of 1 month's rent, or if you're moving, they provide security deposits. It's really, really a good way to get kind of a quick assistance. Okay. And so continuing on the current situation with evictions, a lot of people believe that there are that if they get served with a 3-day notice because they can't pay their rent, that the sheriff is going to immediately come the next day. That's not true. That is a stereotype maybe perpetuated by television, but that's definitely not true. If you get served with a 3-day notice that looks something like this, the landlord has to wait until the expiration of the 3 days before they go to court. There can be no evictions that are simply moved based on a landlord giving a piece of paper to the tenant. Everything has to go through the court. So even if you don't have a formal lease agreement, the landlord still has to go through a process of serving you with a certain notice, certain notice period. And then after that expiration, they have to process it through court. Only after a judge orders an eviction can the sheriff can a landlord have the right to lock a tenant out of the property. So these are the steps listed out. Number 1, you'll receive a lawful eviction notice. Number 2, the notice expires and the landlord goes to court to file the unlawful detainer. In step 3, a judge orders the eviction and then the sheriff will come. So that's once again, and so when a tenant does get a notice, they'll come to us and we have to see, determine if it is valid or not. If it's not valid,
can you hear me?
To write a letter to the landlord addressing the invalidity. And usually what happens is the landlord will reissue a new notice to and then the landlord, the tenant will get that new additional time before the landlord gets the right to go to court and file the unlawful detainer. So this is a little chart in which it shows the process of an unlawful detainer. What happens when you finally do get to court? You'll have 5 days to respond to the complaint. So the landlord files in court and eventually, and they serve you with the papers. And so once they serve you, you put on notice that you have 5 days to file an answer. If you don't file an answer, you go into default, and it's a judge orders an eviction just because you didn't show up or didn't respond. But within that 5 days, you respond in court, and then you'll get an opportunity to go to a mandatory settlement conference. At that settlement conference, the landlord and the tenant come together, and their attorneys or their legal aid attorneys come to the table through the court and try to come up with an agreement to prevent an eviction. So sometimes the agreement is that, okay, I'm going to be able to pay the money that I owe in this amount of time, and if I don't, I'm going to go through to get an automatic eviction, or I can't pay, I just want some more time to move out. These are the reasons why I believe I should get this amount of time, and we make it a deal based on that. So that's where we try to get clients to think really carefully and try to come up with some type of negotiation, because the alternative is going to trial. And if you lose at the trial, the stakes are really high. You get an eviction on your record, and it makes it really, really hard to rent going forward. And at Legal Aid, we are limited in staff and resources, so we're not able to represent clients at trial. And so we really do try to find help the clients reach the best opportunity for settlement and negotiation at that conference. And so on the left-hand side of the chart, it does show if a tenant goes into default, if they don't respond to the court documents, what's going to happen. And, you know, basically a tenant will have about 5 or sometimes it's 10 days before the sheriff will come and remove their belongings. So yes, that is a very scary process towards the end. And, you know, we hope that no one has to go through that ultimately, because it is definitely a scary situation. But yeah, as you can see there, it's multi-layered, and it's not simply like, I get a notice from my landlord, the sheriff is gonna come the next day. So I hope that everyone sees that it's a very long process before that happens. Okay, so after, you know, seeing all of this information, or after having been a tenant for many years, you might feel that you don't have a lot of rights or a lot of power. The landlords, especially in this county, have a lot of they're able to charge a lot of money, and, you know, because of the current situation, there's not a lot of renter protections. You might feel like you don't have any wiggle room to stand on. First of all, know that there are laws against retaliation. So if you do stand up, you know, for yourself in any situation, and you face, you know, some type of penalty like eviction or whatever from that, know that there are laws in place to protect you and safeguard you. As tenants, you do have rights. So know your rights, ask questions, be educated, and organize. The tool of organizing amongst yourself, if you are in a big complex, especially, or even if you're in a small complex with a couple other neighbors, you do have power in numbers. So getting all your fellow tenants together to form a tenant association is something that is we suggest that people do, and we have helped different complexes in the community come together and try to form these tenant associations to, you know, start petitions, start protests, and start like mini movements to get you know, rent increases overturned, or to get trash collection going, or to get really big habitability issues resolved. And so, you know, it is a lot of work for the individuals to come together and take the time to do that. But that is sometimes the best way to make change, because, for example, for rent increases, and maybe some of you guys are facing those, you know, there is a big leeway right now in which the landlord can increase the rent to 10% now. That's a new figure. It went from 8.8% last year to 10% recently. And there's not much you can do other than, you know, try to organize against the landlord and try to get it reduced, because, you know, the law is not going to be able to help on your side, because the new limit is 10%. So organizing and making your voices heard is something that is effective. And when you elevate your voice, you also seek to get other community members involved. Maybe there's, you know, not just the tenants that are in your building, but you want to start going to board of supervisor meetings and get involved in other organizations that advocate on behalf of tenants. And, you know, getting all of these voices in your corner can help elevate your cause to the city, the county level, and even the state level. And so, yeah, this is just another slide about community participation, learning about policies that affect your neighborhood, and participate in creating new policies that are beneficial to you and your community. Once again, you want to show up at those board of supervisors meetings, town council meetings, to speak up about your experiences, and show the elected officials, you know, what is actually going on in the city in which you live in. And you want to start forming different, start different conversations at your churches, schools, or any community gathering places, because that's how grassroots efforts start at the small granular level. And with more people getting involved, it leads to bigger change.